Hello, and welcome to UK Employment Law, the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights recent case law and legal developments of importance to UK employers. It is presented by members of Mayor Brown's employment team and occasionally features special guest speakers who are involved in changes in employment law. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions. We hope you enjoy the podcast.
Hello and welcome to the Mayor Brown podcast. I'm Chris Fisher, head of the London Employment Group at Mayor Brown. In this episode, I'm looking at a recent Court of Appeal case about when an employer should offer a right of appeal against a redundancy dismissal. And this is the case of Gwynedd Council v Barratt. Now, whether or not to offer an appeal against a redundancy dismissal is a question we are sometimes asked by clients because, unlike disciplinary dismissals and grievances, the ACAS code does not apply to redundancy. And although the ACAS guidance recommends an appeal in redundancy cases, the guidance does not have statutory force. So the facts of this case concern two teachers employed in a school by Gwynedd Council. The council decided to reorganise a number of its primary and secondary schools and to consolidate them into one new community school for both primary and secondary school age children. The process the council adopted was to inform all of the teachers at the existing schools that their employment contracts would terminate, but that before then they would have the opportunity to apply for jobs in the new school by way of an application form followed by an interview. Unsuccessful candidates would then be made redundant, with the successful ones taking up roles at the new community school. So the case here was brought by two of the teachers at the school who applied for and were interviewed for new roles, but they were unsuccessful. They claimed unfair dismissal, arguing that the council had not adopted a fair process because there had been no consultation at all, they said. They claimed that the council had simply dismissed those who were unsuccessful in the application and interview process. And a specific part of their argument was the fact that the council had also not allowed any appeal against the dismissals. The Employment Tribunal found that the process the council had followed was indeed unfair, and in particular they commented on the lack of an appeal being offered. The tribunal judge said that an appeal was ingrained in principles of natural justice and that it would require truly exceptional circumstances to refuse an employee a right of appeal against a dismissal, including in redundancy cases. The council appealed on various points. On the appeal point, they argued that the judge had applied the wrong test and that the absence of an appeal in redundancy cases should not make a dismissal unfair. And much of their argument was based on a 2005 case called Task Force and Love, where the EAT had said that it would be wrong to find a redundancy dismissal unfair because an employer had failed to provide for an appeal hearing. The Court of Appeal considered the Task Force case, but they said that the comment by the EAT in that case had to be looked at in context of the other comments that the court had made, and it was clear that what they were saying was that the lack of an appeal in a redundancy process does not of itself make the dismissal unfair, but it could be and can be one of the factors that might lead to an unfair dismissal finding. And in the case here, they said that while the judge's test of truly exceptional circumstances might not have been correct, his overall conclusion was justified, i.e. that the lack of an appeal in the council's process did indeed contribute to the overall unfairness of the dismissal process. Now, when you read the full judgment in the Gwynedd case, it's not difficult to see why this was the court's conclusion. First of all, there was a statutory right of appeal in this case, which the council ignored, and that was because there is a set of local Welsh regulations known as the staffing regulations, which in this case required the council to consult with the teachers and to provide an appeal against any dismissal. And of course, the council hadn't done any of that. So 2 lessons for employers from this case, I think, are first that where an employer is adopting a redundancy or restructuring process that requires employees to apply for roles in the new structure, it's important not to forget that there will be a need for consultation outside of the interview process. The interviews on their own are unlikely to be enough. And secondly, there may be cases where a sufficiently thorough selection and consultation process has happened and an appeal will not be needed for a fair dismissal. But in many cases, I think an employer's view will be, why take the risk? Why not allow for an appeal? Because apart from anything else, an appeal will flush out any arguments of unfairness that the employee might be looking to bring, and it will give the employer a second chance to rectify any flaws in the original process. So I think all in all, an appeal in redundancy cases is going to be the safest course, but as this case confirms, the lack of an appeal will not necessarily make a redundancy dismissal unfair. So that's Gwynedd Council and Barratt, and that's the end of the podcast. I hope you found that useful. If you have any comments or questions, as always, please do contact me. And until next time, I hope everyone stays well, and I look forward to speaking to you again. Bye for now.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Christopher Fisher, Head of Mayor Brown's London Employment Team, at cfisher@mayorbrown.com. Thank you for listening to the podcast.